Good morning. My name is Deepak Premkumar, and I'm a research fellow at the Public Policy Institute of California. Welcome to our virtual program today featuring the findings of PPIC's latest report, What Happened When California Suspended Bail During COVID. The report, technical appendices, policy brief, and slides from today's briefing can be found on the website at ppic.org. This research and today's event are sponsored with funding from Stand Together Trust. We'd like to thank them for their support. For today's program, I'll present some of the key findings from the report and then invite my colleague, Sean Kremen, to join me and answer questions from our virtual audience. If you have a question, please send it along with your name and organization to the email address on the screen. That is ppiceventquestions@gmail.com. As a reminder, PPIC is a public charity and does not take or support positions on any ballot measure or legislation, nor does it support, endorse, or oppose any political parties or candidates for public office. And now, on to the presentation, which I'm excited to talk to you about what happened to California when it suspended bail during COVID. Before I go into what happened during COVID, I first want to provide an overview of what bail in California looked like prior to the pandemic. First off, let's define the term. Bail is the amount an accused person must pay as a deposit to the court to be released from jail while their judicial proceedings continue. It's initially based on the arrest offense, and there's an associated dollar amount with each arresting offense. That is called a bail schedule. Ultimately, the bail one faces is eventually set by a judge. Now, these bail schedules are developed separately for each county, and bail can regularly reach up to tens of thousands of dollars. And previous research has highlighted wide variation in bail amounts for the same offense prior to the pandemic. And counties have different release conditions and capacities. Other research has highlighted that about 40% of individuals booked on misdemeanors or felonies were released pretrial in California. Aside from these COVID temporary emergency bail measures, the bail landscape has been shifting in California over the last 5 years. And primarily that is because of court cases challenging the constitutional nature of whether bail is equitable for low-income defendants. Now, what happened to bail during COVID? As we all know, the COVID pandemic presented several challenges for California. The Judicial Council of California tried to understand how to reduce viral transmission in courts and jails. One of the solutions they implemented was a statewide emergency bail order that reduced the number of people being held in jail for pretrial detention. This was in place from April to June of 2020. What this did is it set bail at $0, essentially flattened the bail schedule and set it to $0, but it did make exceptions for most serious sexual and violent crimes. However, there were some controversial elements, including some felonies that were zero bail eligible that we as researchers categorize as violent. So what this means is if you are arrested for these zero bail eligible offenses, no payment is needed to be released pretrial. You're arrested and then immediately released. This is quite different than when people discuss bail reform or non-monetary release frameworks, which typically use things such as risk scoring to determine whether or not to detain someone. Importantly, in the statewide emergency bail order, there was an exception allowing the district attorneys and law enforcement to allow them to appeal for a different bail amount. And after June of 2020, when the statewide order expired, about half of counties kept modified zero bail orders in place. What does that look like? It meant that a lot of counties started with the Judicial Council of California's orders, but then added additional exceptions for bail. One example is Los Angeles County, which reduced the number of individuals that were allowed on zero bail by saying, for example, if you were released on a zero bail eligible offense and you committed another crime, regardless of what that other crime was, you were going to be detained and they would use the bail schedule. Now, Because there were some increases in crime since 2020 in certain violent and property crime types, and Californians grew more concerned about crime, some criticized these emergency bail measures as providing a revolving door effect where people would be arrested and then immediately released. And because they highlighted these measures as a potential determinant of some of the crime increases, it's vital to understand their impacts. This figure highlights the percent of California's population under zero bail, or represented in this figure as ZB. And that is shown in blue. In orange shows the percent of California counties that had a zero bail order in place. As you can see, so the statewide order happens from April 2020 to June of 2020, where 100% of counties and 100% of California's population sitting under a zero bail order. However, about 7 counties covering 44% of California's population implemented an order early, and 27 counties with 84% of California's population continued having an emergency bail order after June of 2020. In fact, a majority of California was living in a county that had an emergency bail order in place until July of 2022. And when we look at the end of our sample, which is the last time we talked to county superior courts about whether they had an emergency bail order in place, we found that 3 courts did: Sacramento, San Bernardino, and Glenn. However, for San Bernardino and Glenn, all felonies were not eligible for zero bail. You may be wondering why there is a significant jump in the population of California that had emergency bail order in place. And that's from a court case that I discussed, where a court case in LA that had challenged the validity of cash bail and how it was currently being applied reinstated their Los Angeles's zero bail order from May to October of 2023. And that court case is called the Urquidy court case. Now, what do these zero bail versus non-zero bail offenses look like? For felonies, domestic abuse and assault were the most common arrests that were not eligible for zero bail, or otherwise known as zero bail exceptions. If we were to expand and look at arrests in general, not just felonies, the most common non-zero bail eligible offenses were DUIs and domestic violence. However, a majority of offenses were eligible for these zero bail. And for misdemeanors, the most common offenses were drug offenses or obstructing an officer. Whereas for felonies, there were a variety of different theft offenses, such as vehicle theft or grand theft, as well as drug possession. In this presentation, we hope to answer 2 main questions. The first is, how did rearrests for zero bail eligible offenses change when emergency orders began? The second question is, what happened after these emergency bail orders ended? Now, we wanted to separate this out because the time period in which zero bail orders were implemented was highly volatile and disruptive because of the nature of the COVID-19 pandemic. So providing 2 different estimates allows us to assess whether the contextual factors associated with implementation play a significant role. Importantly, we are not discussing in this report any of the intended health benefits in terms of this policy. For example, lives saved from reduced viral transmission. That is outside of the scope of this report, but is important research to do. So let's get to the data and what the trends are. So in this figure, we show 2 figures of trends in zero bail and non-zero bail rearrests split between misdemeanors on the left and felonies rearrests on the right. The horizontal axis is representing the date in which these rearrest trends take place. The green vertical line is the statewide emergency bail order, which happened on April 13th of 2020. The vertical axis here is showing the share of arrests that are rearrests within 30 days. We split it between those that are zero bail eligible in light green and those that are non-zero bail eligible rearrests, which are in dark blue. These are just trends, nothing causal about these figures. What we see is in the pandemic, focusing primarily on zero bail rearrests, we see a significant shift in zero bail misdemeanor rearrests from around 15% of arrests to less than 10%. Now, that quickly rebounds to the original level and starts to reduce over the course of the pandemic. So we actually see misdemeanor arrests descriptively reduce during the course of the pandemic. However, when we look at felony, zero bail felony rearrests, what we see is they're about 9% of arrests prior to the start of the pandemic. At the onset of the pandemic, we see this large spike in felony rearrests that ends up persisting for a few months and then is gradually reduced. And it isn't until September of 2023 that we see it reach eventually pre-pandemic levels. And this is a point we'll come back to later in the presentation. Now, how are we going to measure the causal effect of the implementation of these zero bail orders? Well, one thing we hope to do is look at the staggered timing in which these counties adopted and revoked these emergency bail orders. We'll be separately estimating the effective implementation and revocation of these emergency bail orders. Again, why we do that is because implementation happens rapidly and coincides with the most disruptive effects of COVID, whereas revocation happens over 3 years in a more relatively stable time period. Assuming that that COVID context is not relevant, we may expect equal and opposite effects of implementation and revocation, which is something we will discuss when we look at our findings. Now, we'll be comparing the effects of rearrests for zero bail and non-zero bail eligible offenses. And the identification assumption is that these rearrests for zero bail and non-zero bail would trend similarly in the absence of a county not implementing a zero bail order. Now, because the COVID-19 pandemic and other confounders may be resulting in other differences that isn't related to these emergency bail orders, what we're going to do is we're going to control for a large variety of potential things that may be driving our effects other than the emergency bail order. We're controlling for state rearrest trends, fixed differences between the counties, the offense category of the initial arrest, and the race of the arrestee. Primarily, we're focusing on rearrests within 30 days of an initial arrest, which is a relatively short time span. The reason we do so is the statewide mandate, which impacted all counties, only lasts a bit over 2 months, 68 days to be exact. And as a result, we wanted to understand its impacts even for that short time period. We do additional robustness checks to see how our effects change if we were to expand that time period, and we find that our results are relatively robust to the expansion of that time period. We also show changes by changes in the offense severity of the initial and subsequent arrest. So what do we see in terms of the impact of implementation? This figure plots the effect of an emergency bail order on rearrests of zero bail eligible offenses. On the vertical axis is the percentage point change in the likelihood of rearrests. The horizontal axis shows weeks relative to a county implementing an emergency order. And that is slightly different between counties because remember, about 7 counties implemented an order early. The red line is a separation between before implementation and after implementation. This black horizontal line denotes there not being in effect, meaning that when orange dots, which are the estimate of an effect in that week relative to implementation, if they're around the 0 line, that means there isn't really an effect. These orange lines around these orange dots are what we call confidence intervals. If these orange lines do not intersect with this horizontal black line, what that means is this effect is statistically significant. We measure the effect from the week of implementation to 10 weeks out. And again, that's because the zero bail, the statewide emergency bail order only lasted for 68 days. So that roughly covers this 10-week period. We also show the effects before the implementation of an emergency bail measure to show that we don't see effects beforehand. The fact that we don't see effects is an important prerequisite for the causal interpretation of the effects of this measure. As we can see from this figure, there is an increase in the likelihood of rearrest, and it grows over time. And it becomes statistically significant about 6 weeks after implementation. You can think of this based on the timing of when counties adopted these measures as during the height of COVID. So this is in roughly late April and early May. If we were to take an average effect over all of these effects over the 10 weeks following an emergency bail order, we'd find that the implementation of an emergency bail measure results in an 8.2 percentage point increase in the likelihood of rearrest. And that's a notable increase over the 14.6% of people who are rearrested prior to implementation. Now, this figure shows the number of the likelihood of rearrest, but we also do other work in the report to show that we find similar findings for the number of rearrests. Now, what was the impact on the revocation of these emergency bail orders? Well, what you can see by having most of these orange dots along this horizontal axis is that there is no significant impact of taking these orders away. And because these estimates are relatively precise, we can rule out relatively small effects of the revocation of zero bail, around 2 percentage points. And this asymmetry between the implementation of zero bail orders having an effect and the revocation not having an effect may give you some pause. But to provide a little bit of context, the revocation of these emergency bail orders starts in June of 2020. But a vast majority of the rearrests under these revocation orders happens between mid 2021 to 2023. And during this time period, COVID was not as prominent, and society may have been functioning relatively normally to the context in which bail measures were implemented. Now, we studied the impact of the implementation and revocation over the course of just a few months because the statewide bail order only lasted 68 days. However, 27 counties chose to continue their emergency bail order for at least a year until April of 2021. And that allows us to study the effect over time for this subset of counties. As counties continued their emergency bail orders, many of them made modifications to them to increase the number of exceptions that were zero bail eligible. So now on this horizontal axis, instead of weeks to implementation, we have months to implementation. We can see that there were no effects before the months before the implementation of these emergency bail orders. However, what we see in the original implementation figure is that we see these increases in the first few months of an emergency bail order. The largest impact is this third month after an order is implemented, which shows a 12 percentage point increase in the likelihood of being rearrested. However, after 4 months from implementation, we start to see that these estimates of the effects become statistically insignificant. And this is roughly starting around August of 2020. And the fact that the effect starts to wane after 4 months is perhaps a reflection of the COVID situation being less disruptive. Or perhaps that some county superior courts who are making continual modifications of their zero bail order are learning from what is occurring in courts and jails. And perhaps law enforcement are making adjustments too. If we were to take an average effect over the year after implementation in these 27 counties, we'd find that the increase in rearrest was statistically insignificant or indistinguishable from zero. Now, when emergency bail orders were discussed in public discourse, a lot of the concern was pressed on whether rearrests were concentrated among certain crime types. There was a concern that initially lower level offenders were being released and then committing much more serious offenses, particularly violent offenses. What this figure does is it plots the average effect of the 10 weeks after implementation. This red line here represents there being no effect. It's similar to the black horizontal line before. And what we do is we break down our effects into different rearrest category types. The top line, any arrest category, is what we showed in the previous implementation and revocation figures, meaning that the initial arrest and the secondary arrest could be of any offense type. When we go to the second category, any arrest specific type, that means the initial arrest is a zero bail eligible arrest, but it could be of any offense type. Whereas the secondary arrest is, in this case, a violent felony defined by the penal code. Now, you'll see two different definitions of violent felony. You'll see the penal code definition of violent felony, which is very specific and defined. And you'll also see a PPIC definition of violent felony. The PPIC definition of violent felony are felonies that, as researchers in the criminal justice space, we've identified as violent. This is a more expansive list than what is in the penal code definition. So we wanted to share the effects using both definitions. Now, we also include estimates of the same arrest type to understand whether people are being rearrested for similar crime types, which was part of the discussion around public safety with these emergency bail orders. And we also look at whether lower level arrests are leading to violent felonies, because again, that was a motivating anecdote. And what we see is that the effects seem to be driven by felony rearrests or being rearrested for a felony. For example, people arrested for a general offense and then rearrested for a felony have an 8.8 percentage point more likelihood, have an 8.8 percentage point more likely of being rearrested within 30 days. And that's over a 5.2% share of those who are rearrested in the pre-period. Now, what does that look like from people who, what does that look like for the set of counties that continued an emergency bail schedule for at least a year, which allows us to examine that impact? These are for those 27 counties. What we find is for general to felony rearrests, we find a persistent increase in the likelihood of rearrests. And unlike the impact on any rearrests or general rearrests, there is no subsiding effect after 4 months. Now, this aligns with some of the concerns related to public safety. We don't find an impact on violent felonies, but it is notable that we do see this increase in felony rearrests. Now, what does it look like for revocation? What we find is across rearrest offense types, there is no impact on revocation, has no impact on rearrests. Now, how does this compare to bail changes elsewhere? Again, these zero bail orders were expansive policies, both in the challenges associated with the COVID-19 pandemic and the original motivation to reduce viral transmission. So there aren't great analogs to what we can compare to. However, there are programs from Kentucky and Texas that focus on primarily lower level offenses that do not see an impact on increases in offending. If we think of more bail reform issues, such as using algorithmic risk scores instead of just releasing people based on arresting offense, we can also see that there aren't significant increases in offenses in those contexts. And again, these are contexts that are not related to the COVID-19 pandemic. So, as a recap, what we find is that the implementation of these emergency bail orders led to increases in the likelihood and number of rearrests within 30 days. This is driven by felony rearrests. However, there is no evidence that there are increases in rearrests for violent felonies. For counties that continued the order for at least a year, what we find is that the effect wanes after 4 months while a measure is still in place, and that the average effect becomes insignificant over the year after implementation. This is not true for felony rearrests, which have a significant and enduring impact. Revocation, however, did not impact rearrests, the revocation of these emergency bail orders, regardless of offense type. Now, what do we learn from this? This presentation shows that there are some short-term risks to blanket policies on pretrial detention, and that the offense in which someone's arrested may not be an accurate indicator for future risk. Pretrial risk assessments that take into account the whole criminal history, along with other factors, may be a promising approach. It seems like the asymmetry between implementation and the lack of an effect with revocation suggests the context in which these orders were implemented is key. It's possible that reoffending risk at the height of the pandemic may just be different when society's functioning normally, when people in jail can be connected to pretrial services or case management or other community-based programs. It's important to understand why these felony arrests did not decline after implementation. More research needs to be done to understand these contributing factors. One may be that criminal justice outcomes haven't returned to what we saw in the pre-pandemic level, with stops such as in criminal justice outcomes such as stops, arrests, and jail populations, which have been significantly reduced and not returned to pre-pandemic levels. Importantly, this project is not evaluating the existing cash bail system or other bail reform measures, just highlighting some short-term risks from these emergency bail orders implemented during COVID. Future research should also examine the benefits or longer-term impacts on rearrests. For example, this policy was implemented to reduce viral transmission in COVID, but it was outside the scope of this report to evaluate that question. I now invite my colleague, Sean Kremen, to continue the question and answer part of this presentation. If you have a question, it's not too late. Please send it to ppiceventquestions@gmail.com. It's now time to answer our audience questions. Thank you, Sean, for joining us.
Hey, Deepak, thank you so much for that great presentation. We already have our first question in from a viewer from Sacramento who's asking, how do these emergency bail orders compare to bail reform efforts in California or other states?
It's a great question. It's something I highlighted in my last slide, but these are pretty significantly different. It's incredibly important not to conflate bail reform efforts in other states with what was done because of COVID-19. I mean, the emergency bail orders were expressly in response to limiting viral transmission in courts and jails, reducing pretrial detention populations. And we also didn't have many other resources to provide those people released during this highly disruptive period. On the other hand, when we talk about bail reform, and in this report, we have two technical appendices discussing bail reform in California and bail reform in other states. That's typically focused on changing pretrial detention and release decisions that are making them refocused on public safety and court appearance rather than the amount of income someone has. So in terms of bail reform efforts in California and other states, I'd suggest people take a look at our reports, but I would like to highlight that these are quite different.
Thanks, Deepak. So we have our second question in from a viewer in the Bay Area in Berkeley. Why might there be no significant effects after revocation of emergency bail measures, but we see an increase in rearrest during the onset of COVID when zero bail orders were implemented?
So that's a great question. It's something that we wrestled with when we found our findings. One aspect of this may be the disruptive part of COVID. In general, in a handful of counties in California, there are regular services, including pretrial services and case management, that are provided to people when they're released from jail. And because, especially in those early months of COVID, those were not available. And a lot of community-based programs that are focused on crime reduction or violence interruption were also not in place. We do seem to find that as we look at the effects of implementation, the impact on rearrests start to wane and start to diminish about 4 months after implementation. So the context of COVID seems important, and it's possible that these programs that are there to support individuals restarted. It's also possible that county superior courts that are modifying their emergency bail orders are learning from what they see based on who is entering and leaving the county jails and courts. And perhaps law enforcement made some adjustments as well.
Thanks, Deepak. And we have another audience question. Are people being rearrested more because they have more opportunities to offend as they're not being held in jail? Or because they interpreted the consequences to be lower because they would just be released? I think this is getting to discussions around incapacitation and deterrence effects.
Yeah, that's exactly right, Sean. So this is a great question. So there could be like two driving forces, or there could be multiple, but criminologists often focus on two driving forces in which we see increases in rearrests. The incapacitation story is that someone is just held in jail, so they're not able to commit more offenses because they're not in the community and don't have those opportunities. The other is that potential criminal offenders interpret an emergency bail order and a handful of offenses being $0 bail, meaning they'd be arrested and released, as there note being a reduction in consequences and then committing more crime as a result. We provide suggestive evidence in the report that I didn't really get to chance to go into detail here, that it seems likely that it's an incapacitation story. In fact, when we see increases in rearrests, we find evidence that it happens in the first 6 days after an initial arrest is made, which is kind of providing evidence to us that the counterfactual or the other type of people who are not being arrested for zero bail eligible offenses are just kind of sitting in jail during that time period, and then they're being released. For felony offenses, we find that people are most likely to be held for a little bit longer, which provides some evidence that this is likely an incapacitation effect.
Thanks, Deepak. Our next question comes from Thomas Sloan in Oakland. Were you able to decompose the types of felonies that were responsible for the sustained rearrest effect?
It's a great question, Thomas, which I appreciate you asking this question. One of the things we tried to do in the report is first find the most rigorous estimate on rearrests and then change the offense severity. In terms of decomposing it to actual crime types, whether it's violent crime or property crime, we start, especially with the number of controls we have, we start really reducing the number of observations that we can estimate an effect from. We hope to do more work in trying to understand what is driving these changes in felonies. We currently don't have an exact answer for this.
Thanks, Deepak, and thanks, Thomas, for that question. We have another question. Can you speak more to the overall magnitude of the public safety impacts that you've found? How do these percentage point increases translate to overall crime or arrest rates?
So the overall, because we're focusing on the likelihood of rearrests, some of the effects we found, particularly in relation to felony rearrests, are significant in that, for example, the implementation of these emergency bail orders causes an 8.2 percentage point increase in the likelihood of rearrest, where the base rate is roughly around 15%. Now, those are substantial increases in rearrest, but rearrest as itself isn't necessarily the most likely outcome, especially rearrest within 30 days. We haven't been able to assess the particular impact of how much does this explain potential crime trends. we think it might be one contributing factor, but not necessarily a driver of a lot of the crime trends that we see during the pandemic.
Thanks, Deepak. And we have another question from Dr. Yakuta. Why did you choose the specific controls that you did? For example, why were age and gender left out?
So that's a great question. In our model, we ran it with several different specifications and used several different types of controls. And we actually find that the general findings are robust to all of them. In one of our specifications and estimations, we did control for age. I'm not sure if I remember the effects related to gender, but I know if we include age and age squared as a control, the effects are largely the same.
Thanks, Deepak. All right. Here's another question from a viewer. It seems the rearrest effect is driven by felonies and they still remain higher for at least a year. So why do effects on general rearrests wane over time?
Yeah, that's a great question. It might seem counterintuitive because the general rearrest effect is driven by felonies and they're not subsiding like we see in roughly around 4 months for the general rearrest effect. Like, why is this happening at all? An important thing to keep in mind is that a significant share of rearrests are actually misdemeanor rearrests and are not felony rearrests. And these type of offense types face some reductions. There are some reductions in misdemeanor rearrests during this time period. They're not always statistically significant. So in this short presentation, I chose not to focus on them. But I did want to highlight that this discrepancy because it is a curious finding that these rearrests, felony rearrests, don't go down.
Thanks, Deepak. And our final question comes from a viewer in the San Francisco area. You mentioned counties making modifications to their emergency bail orders. How common was that, and how did you take this into account in your analysis?
Yeah, it's a great question. And in fact, actually, an extensive part of this study that I wasn't able to cover in this presentation was the incredible labor that our research associates, such as Sean and Andrew Skelton, put into identifying, finding, and determining when an emergency bail order was in place in a county, the number and specific offenses that are included as exceptions or non-zero bail offenses in these emergency bail orders. It took a lot of work to reaching out to county superior courts to determine a timeline of these effects. What we found is that many counties continued, 27 of them continued these emergency bail orders. And the counties that continued them often made numerous modifications over the time span in which an emergency bail order was in place. So it really does align with sort of this adaption story where they're making decisions and adding to the list of non-zero bail eligible offenses. So in other words, we find that a certain county, like Los Angeles, for example, would release multiple different bail schedules as time went from 2021 to 2022. I hope that makes sense.
Great. Thank you so much, Deepak. And with that, we've reached the end of today's program. First, I'd like to thank Deepak again for that great presentation and the excellent discussion. We would also like to thank Stand Together Trust for their support of today's program. And thank you to you all for joining us online. We would appreciate you taking a moment to give us your feedback on this event. If you pre-registered for this event, you'll receive an email with a link to a short survey, but you can also scan the QR code on your screen right now. Finally, a recording of today's event will be available in the coming days on the PPIC website and our YouTube channel, so you can watch it again or share it with your colleagues. Thank you and have a good day.